Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV130355, Cornerstone Bank versus CR1 Holdings, LLC et al. Counsel, we are recording today's proceedings, so when you step to the podium, if you would, please state your name and the party that you represent. Each side will have 20 minutes for argument, and counsel are responsible for watching the clock and reserving any time for rebuttal. I know there's a cross appeal, and the bottom line is you get 20 minutes. In theory, happily would get the last word because of the cross appeal, but use your 20 minutes however you wish. We've read the briefs, we've conferenced the case prior to argument, and with those preliminaries out of the way, counsel for the appellants, you may proceed.
Thank you, Your Honor. Michael DePaula here for appellants CR1 Holdings and CR1. My clients, Mr. and Mrs. CR1, are at the table with me. I'd like to start with ARS 12-349. The statute is a checklist. You go through the statute, you see if sanctions can be imposed based upon the actual words in the statute. 12349A4 allows sanctions if a party engages in abuse of discovery. There's no evidence that CR1 engaged in abuse of discovery, so that does not apply. 12-349A3 allows a sanction if CR1 unreasonably expands or delays the proceeding. Now, there is no evidence in this case or finding in this case that CR1 acted unreasonably, that he expanded the proceedings, or that he delayed the proceedings. And without specific findings and specific evidence to support those findings, you cannot use that section, that part of the checklist, to impose sanctions upon CR1.
Tell me about, if you would, counsel, the findings requirement. Where do you find that?
ARS 12-350 has a requirement for findings, and there are several cases cited in our briefs which also show that findings are necessary. 350,
though, talks about findings for attorney's fees awards, right? Not sanctions.
It does, Your Honor. That's my understanding.
Wasn't the issue that your client appealed here a sanction as opposed to an award of attorney's fees?
My client paid the sanction of $5,000.
Right. And I guess what I'm asking is, does 350 require findings for an award of sanctions, or is it limited to attorney's fees?
You know, that's one of the problems in this case that we have raised, is that we believe the trial judge was random in its assessment of a sanction because it cited 12-349. The motion was under 12-349, and yet it just imposed a sanction without connecting the sanction amount to the actual conduct.
And I understand that, and
right.
I want to get to that.
Right.
But you started with that there weren't appropriate findings.
Correct,
and what I guess I'm looking for is the authority that required the findings that you claim weren't made. And I didn't find it in 350.
Okay, Your Honor, I find it in State v. Ritchie, Phoenix Newspapers v. Department of Corrections, and also in Bennett v. Baxter. It says the trial court must set forth specific reasons under the statute. That's how I read it.
That's for attorney's fees or for sanctions?
The way I read it, Your Honor, is both.
Okay.
I believe you can't sanction. I believe you cannot sanction under 12-349 unless you meet the checklist requirements of the statute. And I think the statute is very specific. And
and which statute? 350 or 349?
I'm talking about 12-349, Your Honor.
Okay, because I don't see a findings requirement in 349.
The findings requirement is not stated in 12-349.
Okay.
Right. The findings requirement is stated in 12-350 in the statute.
Right, and that's where I get, for attorney's fees, I'm with you.
Okay.
But for sanctions, I just don't see it in 350, and that's why I wanted to raise the issue.
Okay, and it's my belief that when you read these three cases together, State v. Ritchie, Phoenix Newspapers v. Department of Corrections, and Bennett v. Baxter together, and also Fisher versus National General Insurance Company.
But which of those were sanctions as opposed to attorney's fees? Several of those are attorney's fees, and the statute 12-350 by its own language says in awarding attorney's fees pursuant to 12-349. So which of those cases you're citing was a sanctions case as opposed to an attorney's fees case?
It's my understanding that the Fisher case was about sanctions according to our blurb here, and it's also my understanding that the type of sanction can either be a award of attorney's fees or award of costs under the actual statute. So 12349 does say there's two things you can award. You can award attorney's fees, you can award costs, and then it says you can award double the damages. And so I think the only way to interpret the word double the damages is to relate that back in the same sentence to costs and attorney fees. So when I read that statute, I see it as saying that there's only two types of, quote, sanction you can get underneath this 12349 for the delineated problems, which is attorney's fees and costs. And also, under the Bennett versus Baxter, that case specifically says that the sanction amount has to relate to the wrongful conduct. And I think when you put those two together, I think it's very clear that the statute is on its face restricted to its own words. And when it's restricted to its own words, the only, quote, sanction it allows are attorney's fees and costs, and that amount doubled up to a maximum of $5,000. So you can double the attorney's fees and double the costs up to $5,000. There's no other sanction that appears to be allowed by that case. But to get to that point...
That, with 349, though, that's not... The statute uses three terms, right? Damages is a sanction, costs, attorney's fees.
Yeah, in reverse order, and it does say double the damages.
Right. No, that's absolutely right. It's not in that order, but so I view it as contemplating three different types of things, not two.
You're right, Your Honor, and it's my understanding that you were saying that somehow there is an allowance for a generic sanction under 12349, and my argument is...
If I said that, I apologize.
Okay, I misunderstand too.
That's not my question. My question was getting to your argument that there specific findings were required that were not made under 12350. My concern was I didn't think 12350 applied to sanctions as opposed to attorney's fees. So that, just so we're on the same page.
Right, and I agree with you, but I'm also saying that under the four cases, Fisher versus National General Insurance Company, State versus Ritchie, and Phoenix Newspapers, and Bennett versus Baxter, that the findings requirement is also independent of 12350, that you must use the statute as a checklist. And so I think that Arizona law on these sanctions does not allow just a simple random assessment of sanctions devoid of findings put together under the statute. And so this statute is a limited grant of authority to a trial court, and actually it's a grant of authority to this court too. And so once that authority has been granted, it's conscribed by what has been written. And so...
But your argument on findings is that case law requires findings sufficient for us to, as a court of appeals, to determine the basis and things like that, not that 12350 requires them. Fair?
Yes, yes, correct. Yeah, correct. Yes, I'm sorry, Your Honor. You're right that only attorney's fees will be the other one. You're correct. Okay. Now, if you keep going down the checklist, Your Honor, the next issue is brings or defends a claim solely or primarily for delay or harassment. Now, there's no finding or evidence of that. You know, when I say there's no finding here on these issues on the checklist, it's not just that there's no finding by the trial court. It's that there's no evidence here, and that the bank has not provided this court with citation to authority or to the record as to where there was a defense of a claim solely for delay. They haven't even given you what the delay was. And they haven't even given you what the harassment was. We don't know. We sit here and under due process, we should have a right to know what delay.
Let me ask you, counsel. Are you on A3 now or some other portion of 349?
I apologize. I'm on 349A2.
Okay. Let's come back to A3 for a minute.
Okay.
That's unreasonably expanded or delayed the proceeding, correct?
Yes, Your Honor.
And the minute entry here, what, a 5-page minute entry, something like that?
Something like that.
Gave, it seems to me, some examples of what caught the trial court's attention, at least under that standard, with respect to unreasonably or expanded or delayed the proceeding. Now, you have said there is no evidence in the record to support any of those. Help me better understand that.
There was no delay, Your Honor. They got an injunction preliminarily. Then there was a hearing scheduled. The hearing was held, and an injunction was issued. So there was no delay. And in terms of expanding,
it's not just the delay of the injunction, is it? There are other forms of delay as well that the trial court could have looked at. Is that fair under the statute?
it's my assumption that delay means time,
Right.
and there was no delay of time, and so there's no evidence that time was stalled by anything COSB did.
Okay. Well, wasn't there, and I'm just kind of trailing back to the minute entry, wasn't there sort of a stipulation that certain things that the bank thought were required, turns out weren't required, given information that your clients, the trial court found your clients had provided that wasn't accurate or no longer was accurate?
I'm not sure what that means, Your Honor. I have no clue, because I don't believe that happened. Here's what I think you're getting
Sir,
at.
I understand you may not believe that happened. What I'm working on, of course, is the cold record,
Right.
and the minute entry that the trial court issued, and I think he addressed that, didn't he?
Well, Your Honor, he addressed it in two different ways, and he addressed it first by saying that COSB had no deed of trust interest, which is not true. He then addressed it by saying that COSB had no right to foreclose, which he specifically changed that opinion later on the July 29th minute entry. And so his findings were did not comport with the actual facts, and he actually corrected one of his facts. And then, but when you say, the way you described your preceding question, Your Honor, was there some stipulation by COSB? I don't believe so in this case. Was there did he say something that wasn't factually correct? I don't think so either, Your Honor. And when I say I don't believe so, I'm saying that there's no evidence to support what you just asked, Your Honor. And for example, what I can tell you is that if you look at the index, the date is September 14th or so, or September 12th of 2012. I don't know the number right offhand, but I can find it. I think you're talking about the Charbray property. And in terms of Charbray, Mr. Morgan actually filed a notice with the court showing his exact knowledge of what happened with Charbray. And the issue with Charbray is at best a tempest in a teapot, because the trial judge first said that COSB was enjoined from foreclosing. And then the trial judge said, oh, no, you did not have a right to foreclose, and so therefore I'm going to sanction you. And then the trial judge says, well, on July 29th, well, you may have had a right to foreclose. So I don't know what the true facts are from the trial judge's perspective. What I do know is that the bank had the evidence of the HOA proceeding. The HOA proceeding was minor. The HOA proceeding did not affect the right to foreclose. The HOA proceeding did not preclude COSB from foreclosing. And the HOA proceeding did not stop COSB from getting the excess proceeds from the actual eventual sheriff's sale. Like, for example, in their answering brief, opening brief, opening brief, they make the claim sort of like COSB, did not have the right to foreclose because the Charbray property had already gone to judicial foreclosure as of September 2012. That's not true, because what happened is that there was a stipulation for lien priority in approximately May of 2012. In September of 2012, there was a judgment of lien priority, and then the sheriff's sale did not even occur until January of 2013 after the hearing. So, as of the date of the hearing, COSB had an absolute right to foreclose. There was no redemption right. The judge said Mr. COSB had a right of redemption, but as of the date of the hearing, there was no redemption right at that point in time. Redemption only exists after the sheriff's sale. And so, there's a lot that went on in this case, Your Honor, but this falls back to the case of the standard of what is groundless, which is 349A1, Your Honor. And what is groundless is, and I believe the case is Cypress, but I'm trying to check it up now, is that the question is it fairly debatable what COSB did? And COSB's main argument here, and what the trial judge never responded to, and what the bank never responded to is that this lawsuit was not about what this sanctions motion was. This lawsuit was about an alleged fraudulent transfer that never existed. Their entire complaint was frivolous because COSB had antecedent debt for value. If you have antecedent debt for value under Arizona law, you have a valid lien. You cannot be subject to a fraudulent transfer. Now, that issue is the defense that Kazab was working with. And that was his primary defense, is that there was never any fraudulent transfer. Now, once you get to that point, everything else in this case cannot be found to be groundless. And that's the purpose of the statute, according to its title, is groundless litigation.
Counsel, let me ask you, under A1,
Yes,
that
Your Honor.
does require us to look at the merits.
It
as
does.
you point out. A3 does not, though, does it?
A3 does not require you to look at the merits. That's correct, Your Honor. It requires you to have an unreasonable action, which has not been found by the trial court, that expands or delays the proceedings. There's no time of delay. There's no additional anything in terms of a proceeding that was extra because of anything Kazab did. There was no extra work involved. They knew all the facts going into it. So yes, Your Honor. And also, engaged in abusive discovery does not require you to look at the merits either. So the two of them don't require you to look at the merits, and then two of them do. And with your permission, Your Honor, I'd like to reserve my time.
Thank you. Mr. Morgan.
Good morning. May it please the court. My name is Craig Morgan. I represent the Applee Cross Appellant Cornerstone Bank. Before I begin, I would be remiss if I didn't thank the court for its courtesy of rescheduling oral argument in light of my personal schedule. I want to say thank you on behalf of myself and my family. Before I start, are there any specific questions I can answer for this panel before I go into our client's position in this matter? Okay. All right. With that, and I'm sure there'll be some that come up, I want to address something that was just said, which I think encapsulates kind of the theme of this case. You were just told, Judge Thumma, that what happened below with respect to the Charbray property was that this was I think they called it a priority decision. A decision is the lien priority. That's what was happening there. Well, if you look at the record, the index of record at 36, it's Exhibit 1 and Exhibit B, or if you look at my answering brief, my client's answering brief at page 29, I'm going to read from you what that order in the Charbray property case says. And you think about whether it actually talks about just a priority or if it's a foreclosure of the deed of trust. The interest of, and this is in brackets, holdings, and all individuals, entities, or corporations claiming under them are hereby foreclosed, and I put in brackets holdings, is forever barred from asserting any or all right, title, claim, interest, or lien in and to, and I put the Charbray property because that was the definition in the case, or with respect thereto, accept such rights of redemption as they may have by law. Okay? That's different. That's clearly language that forecloses out the deed of trust, but reserves to them the legal right of redemption. What you just heard Mr. DePauli say is that that was a decision about priority. That's not true. It just so happens that's what this case is about. There was a lot of stuff said below that just was not true. And we come to you on appeal with a standard of review that's this, with respect to the appeal. The court reviews the assessment of sanctions under 12-349 for an abuse of discretion and the factual findings for clear error. And in this case, there is ample evidence supporting the judgment. To say that our client did not provide this court with any evidence supporting the judgment is to either say that I've not read Section 3 of the answering brief or I've read it and completely ignored the footnotes. Because in there, I believe we have pointed to the court to every piece of the record that supports the judge's findings. And there's nothing more we can do there, and there's nothing more we're required to do. And the trial court found alone the lack of candor regarding the alleged deals with the Homeowners Association and M&I Bank and the interest in the Charbray property were sanctionable by itself. That's IR 91 at pages 4 and 5. Judge Herod does an excellent job of outlining that. The problem we have on appeal is the appellants don't overcome that evidence. They don't overcome the record.
Let me ask you, and I appreciate that on the evidence, but what sort of findings were required here?
And Your Honor, the findings required by the court, and I'll refer the court to the decision that we were talking about, you were talking about Mr. DePauli, Bennett versus Baxter. I have it here. And I'm going to read from it. And it's at paragraph 28. ARS 12350 requires the trial court, when making an award under 12349, to set forth the specific reasons for the award. Thus, the findings need only be specific enough to allow an appellate court to test the validity of the judgment. That's it. You need to be able to have enough factual findings to determine whether the judgment is valid. Is there enough in this minute entry, I think it's a, 5-6 page single-space minute entry, to enable you to determine that there was a violation of 12-349, viewing that determination and all the evidence in the light most favorable to sustaining the judgment, because that's the standard of review we've got here? And the answer is yes, Your Honor.
And help me out. We talked some on attorney's fees, expenses, and double damages. I have some feel for what attorney's fees are, what expenses are, but what is double damages there?
Well, Your Honor, double damages is just as the statute says, it's a discretionary award. Nothing more than a finding that 12-349 was violated has to occur for a court to determine whether double damages in its discretion are acceptable. I don't recall the name of a case, but it's either in my reply or my opening brief on a cross appeal. There's at least one case where this court, I think it might have been Jayberg-Wilk, it may be the Jayberg case, where they assessed the double damages before even getting the fee award in. They granted the attorney's fees application on appeal, pending, compliance with Rule 21, but also assessed the damages. I think it was $4 or $5 grand. I don't remember the exact amount, because they had the discretion to do it. It's completely discretionary. And there's nothing in the law that I've read, and particularly in the statute or the legislative history that I provided the court, that requires any sort of specific finding beyond that the statute was violated.
What sort of factual record, though, is required?
Well, the one you have before you, I think, is sufficient.
Help me out a little more specifically.
Right. Yeah, I think at minimum you need a factual record that shows there's been a violation of 12-349. Something that you can look at and say, okay, this statute was violated, so I can understand why the court here is going to determine sanctions under that statute are appropriate. I don't think anything other than that is required, and I think that's what the court has.
But let me ask you, though, in determining, again, I have some feel for what records are required for determining attorney's fees and for costs, but help me with this third category, the damages.
I honestly believe it's the same record, Your Honor. I believe that the record that has to be there is a record that enables this court to determine that 12-349 has been violated. Something.
And I understand that, but it by definition, doesn't damages have to be something other than attorney's fees and expenses?
Absolutely, Your Honor. Absolutely. And again, there's no guidance in the case law about how the trial court is to determine those damages. So what we're left with are cases like, for example, in the Jayberg, I think it's the Jayberg-Wilk case, where the Court of Appeals, it's one of the cases I cite, awarded the attorney's fees and costs on appeal, but also, after they comply with the rule, they had to file their application, et cetera, but also assess the damages based on the record before it. I think nothing more than that, as far as I can tell from the law, Judge Thumma is required. And I think that makes sense given the discretionary nature of the award pursuant to the statute. Now, I would also note to the court that it was the trial court that was in the best position to weigh the evidence in front of it and the information presented. And Cornerstone moved for sanctions under 12-349A1 and 3. The trial court clearly granted the motion under 12-349. It said that in its judgment. And the record is set forth in Section 3 of our papers, I think very, sometimes more so than it should have, explains to the court, here's the evidence that supports the trial court's findings. If there are no other questions on the appeal, I would like to move to the cross appeal. With respect to the cross appeal, the standard of review, as the court knows, is the application and interpretation of the statute 12-349, such as whether to award the fees and expenses, is reviewed here de novo. I think Judge Thumma, you kind of jumped on that at the beginning and said, okay, well, how does the court determine an award of attorney's fees? Well, it's going to look at 12-349, which mandates the award. It's going to consider the factors under 12-350, and it's going to award only reasonable attorney's fees. I don't know if it's expenses or costs. I think it's expenses. And here, Your Honor, we submit that the court committed clear error. It had no choice other than to consider the fee application and award reasonable attorney's fees and expenses. That's supported by the statute. That's supported by the cases that we've cited to this court. That's supported by the legislative history, which I'll remind the court, when that statute was passed, someone actually moved to make it a discretionary award, and it didn't pass. And it's been amended as recently as 2012, and no one has touched the mandatory language in that statute. So when the trial court first said, I lacked a basis to award fees, and we reminded the trial court, well, it's the statute you sanctioned them under, that was wrong. Then the trial court said, I simply declined to. The trial court can't decline to unless it's declined to because it says they're all unreasonable. Here I think it's pretty clear the trial court did not even engage in a reasonableness analysis and had the obligation to do so. And we would ask with respect to that this court reverse and remand in part and require the trial court to actually engage in that analysis with respect to the fees below. And the last thing I want to address, if there are no questions on the cross appeal, is our request for fees on appeal. And having clerked here years ago and sat in various panel meetings, I know attorneys' fees on appeal are not a given, and it takes a unique situation or a mandate by law for that to happen. They're the exception, not the rule. The conduct below has permeated on this appeal so much so that an award on appeal my client submits is appropriate. And I'd like to give the court some examples. For example, the appellants claim that the trial court, and this is on appeal, allowed their redemption period to expire. This is notwithstanding the fact, and this is in the, we addressed this in our answering brief at page 32, notwithstanding the fact of Mr. Kozlov's testimony below that nothing the trial court did precluded him or his clients from exercising their redemption interest. It's a demonstrated falsity, and they said it on appeal in their papers. The appellants spend pages and pages on appeal arguing over the propriety of an injunction they never appealed. They did it today. The injunction wasn't appealed. What happened there, it's over. It has nothing to do with this appeal yet. We have to go through and talk about it and listen about it, and it's brought up here again and again. They try to extract and morph into this record records from other cases in an attempt to speculate about what happened or didn't happen there on this appeal, and they plague this record on this appeal with that information in an attempt to avoid the actual record before the court. They make brand new arguments on appeal, equitable reattachment. That was never raised below. I don't remember seeing it anywhere. That the trial court failed to make the necessary factual findings. Well, we all know that's not accurate because the trial court did just that. And again, it wasn't raised below. They still advance demonstrably unsupported, flat-out false arguments on appeal, and I think it's important when determining whether to award the fees and costs on appeal that you remember this. For example, the deal with BMO Harris Bank, formerly M&I Bank. They still say on appeal we never said we had a deal. I have not been practicing as long as most of the people in this room, but I have never seen such a blatant misstatement in my short career. Because just go to IR 71. There is, I believe it's in bold, all caps and underline heading in one of the appellant's papers, and I'm going to read it to the court. There was a deal with M&I Bank, and there was an attempt to comply with that deal, and that deal was recently affirmed by the bank. And if you go back to oral argument, Mr. DePauli himself at one point said if M&I went back on the deal, and that was at a point during the argument when he was calling it a deal, that they'd have a claim for breach of contract. Yet on appeal, they're still going to tell this court, with a straight face, we never said we had a deal. It's just false. They file briefs making conclusory, factual, and legal statements without citation to the record or supporting law. It's throughout. I know you've seen it. You've read it. They take a completely implausible interpretation of 12-349 on cross appeal. Rather than actually address it or concede the argument, what they tell the court is, oh, well, fees and costs are the damages. So I mean, it's illogical, and there's no legal support for it, none cited. And then they attempt to obfuscate the record by claiming by making arguments that our client made arguments that were never made. For example, they claim Cornerstone somewhere argued Kozub recorded a lien release. We never made that argument anywhere in our papers, anywhere. And again, they still argue a foreclosable interest in the Charbet property, but as I pointed out to the court a moment ago, that's not the issue. They may have had a foreclosable interest before they stipulated to being foreclosed out. But the fact that they got the excess proceeds in the judicial foreclosure action merely means that there were excess proceeds and they were next in line to get them. They didn't have a foreclosable interest. They had a redemption interest. They didn't bring it to the court's attention until it was too late. And on appeal, they still urged that they were telling the truth the whole time. And finally, probably one of the biggest examples of statements or misstatements on the record that have seeped over into this appeal, in my opinion, is when they're talking about their answer. And in their papers, they state, for example, and we addressed this on our brief at page 35, that certain claims in the complaint were, quote, simply false or, quote, not correct. Below, when answering those claims, they claimed a lack of sufficient knowledge or information to admit or deny. Now on appeal, they're saying, well, they were false or incorrect. So either they had an obligation below to deny it, and they lied then, or they're lying to you now. The point is they cannot have it both ways. And it's this type of conduct that this court cannot allow to occur. It happened below. Judge Herod didn't stand for it. It's happened here. This court shouldn't stand for it. I know an award of fees on appeal is the exception and not the rule, but I implore the court that justice dictates here that an award be made. And if there are no further questions, I have 5 minutes and 32 seconds. I'd like to save them for rebuttal and reply.
Thank you.
Thank you.
Rebuttal?
This. The good news is we both admit the trial court made a reversible error, so we at least have some kind of common ground to work from. In terms of this accusation again and again about Charbray and Kozub's lien holdings, he's just reading this and he's not seeing what the words that are there. He quoted the stipulated judgment and he misses the words claiming under them are hereby foreclosed. That's a lien priority. And we know that his argument is wrong on Charbray because Kozub got the excess proceeds from the sheriff's sale. Now, he had a foreclosable interest. We also know that Mr. Morgan's wrong because the trial judge admitted 3 months later, oh, Kozub may have had a foreclosable interest. Therefore, it's fairly debatable. Therefore, there's no right to sanction under this. So he keeps saying that there was no foreclosable interest. That's just wrong. These lien priority, he cannot be ignorant. The bank cannot be ignorant that lien priority lawsuits happen all the time. You stipulate to lien priority. That does not eliminate the lien. But one of the points he tried to make, which, by the way, if you are serious at all about what he just said on the oral argument, I request the right to a hearing on those sanctions he's bringing up now, and I request the right to respond in writing because, for example, he just made this argument that we claimed that there was some kind of lien release, and no, what he said is just the exact opposite. What we said is that the stipulated judgment cannot be a lien release because it doesn't comply with the statute of a lien release. And so he is twisting the words around to try to say that we said something we didn't say to prove an argument that's irrelevant, because the relevant part of this argument is that there was no fraudulent transfer. There could not have been legally a fraudulent transfer. Kozub went out of his way to try to explain all these various comments, all these various arguments, to try to explain why this was all wrong. He cited 4 statutes that all show no fraudulent transfer. They're all in our briefs. Those arguments have not been responded to. They claimed that there was wrongful institution of wrongful proceedings, etc. They haven't told what was wrong about Kozub's argument. What fact shows that his claims were groundless? They haven't shown that evidence. They haven't shown what evidence Kozub acted in bad faith. They have not shown what evidence there is that what proceeding was expanded. This went really quick. They filed the lawsuit in July 2012. The hearing was on October. The motion was entered by November. I mean, the order was entered by November. What was the proceeding that was expanded? We don't know. In terms of the delay, what was the delay? We don't know what the delay is. There's no evidence of delay. There's no finding of delay. We both agree that the trial judge misapplied the statute. But the trial judge must relate a sanction to the statute, and that's why it's a checklist. You must relate the one to the other ones. And also, regardless of the actual issue of findings, the findings must be supported by evidence. This court is required to review, even under the high standard of clear error. You must review the evidence, and you cannot review the evidence because they're hidden in voluminous footnotes, and you cannot figure it out. But when you do look at the evidence, what you'll see is that Kazab didn't say what they say he said. In fact, you'll look to see that when they say Kazab, that they deleted portions of their argument, and this is all in our brief, they deleted portion of our argument. They misquoted what Kazab said in the actual transcript. Now, with all due respect, this court has to go back over the transcripts. And because they have not cited the section of what Kazab did wrong and what he said wrong. And when you go back and you look at it, what you're going to find is that Kazab did not say that he knew nothing about the North Dakota litigation. He didn't say what they said. What he said was he wants to relitigate it because he was not a party. That's what Kazab actually said. When you talk about the M&I Bank, Kazab said 2 or 3 times that he's working on a deal. We said that we're attempting a deal in the part he just read. When you attempt a deal, when you work on a deal, that doesn't mean a completed deal. It's as if counsel doesn't understand what the word inchoate means. Because you can have a deal that's inchoate and it's still a deal. That just means you're working on it. And people say that all the time in English, and that's just part of the English language. Now, in terms of the allegations against them, the bank, in our reply brief, in our reply brief and answering brief, we outline numerous areas where they have taken liberties with the facts, and we respectfully request you look at that because, for example, the one issue is they claim that we looked at. That we waived the objection when we did not, and that's just clearly obvious because we did not waive it. My time is up, Your Honors. Thank you.
Thank you. Mr. Morgan, I did not hear any argument relating to your cross appeal, but if you did, you may have rebuttal as to that issue.
Okay.
But only that issue.
Thank you, Your Honor. Only to the extent that in our cross appeal, again, we did ask for an award of attorney's fees on appeal pursuant to both 12-349 as well as Arizona Rule of Civil Appellate Procedure 25. And I would submit, again, what you've heard is further information for this court to take into consideration when determining whether that award is proper on appeal. Okay? We have cited the court to the record. We've given the court the entire record. We have made no misstatements in the record. Contrary to popular belief, I actually do understand a little English, and I think what we've written is completely accurate, and what we've quoted is equally accurate. And I would ask the court to strongly consider what it's heard today when making the determination whether to award fees and costs on appeal. Are there any other questions for me? Thank you for your time. Much appreciated.
Thank you for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.